Senator from Illinois.
Mr. President, I have 6 requests for committees to meet during today's section of the Senate with the approval of the majority and minority leaders.
Duly noted.
Thank you, Mr. President. Mr. President, earlier today, as we just heard from my colleague in Texas, the Judiciary Committee held a hearing on the abortion ban that took effect in the state of Texas earlier this month. I hope every American who tuned into this listened very closely, because here's what we heard. My Republican colleagues on the committee literally made no effort to defend the Texas abortion law, the Texas abortion ban, SB 8, it's known as in Texas. Not a single effort to defend it on its merits. They made no effort to engage on the issue of the shadow docket process through which the Supreme Court allowed this bill to become law, and they made no effort to argue that women's constitutional rights should be protected. What we witnessed today during today's hearings was the opening salvo on the fate and future of Roe versus Wade. Here are the facts. This Texas law is no ordinary piece of legislation. To quote Supreme Court Justice Sonia Sotomayor, it is, quote, a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny. This law has effectively banned abortion after 6 weeks in the nation's second largest state, even in cases of rape and incest. The fact is, Madam President, many women do not even know they're pregnant by 6 weeks. The architects behind SB 8 took an extreme proposal that clearly violated Supreme Court precedent and paired it with a new disturbing private bounty hunter enforcement scheme. And they did so in the hope that the courts would not block the law because it wasn't clear who should be sued. At midnight on September 1st, the Supreme Court allowed SB 8 to go into effect. As a result, millions of Texas women have had their constitutional rights challenged and suspended. This attack on women has already caused irreparable harm to countless women who lost their right to reproductive care in Texas. At today's hearing, we heard from Donna Howard, state representative from Texas. In her written testimony, she shared the story of a woman who was denied the health care she's entitled to under the federal Constitution. The woman went into an appointment on August 31st of this year, and at the time there was no heartbeat detected on the state-mandated sonogram. But when she came back the next day to have the procedure done, a cardiac motion was detected. Representative Howard said of this woman, quote, at only 5 weeks of pregnancy, she was too late to receive an abortion under the provisions of this new law. She was devastated. She already had a child at home and knew that bringing another child into their lives threatened her family's situation and their financial security. As Representative Howard went on to note, having an abortion was, quote, the right decision for this mother's life and her family's well-being. But the Texas law went into effect, and the Supreme Court deprived this woman of her constitutional right. SB 8 marks a turning point in the decades-long campaign to undermine the Supreme Court's holding in Roe versus Wade. For years, legislative efforts to ban pre-viability abortion have been stopped by the courts, until now. The legal architects behind this Texas law crafted a scheme to avoid judicial review. They lifted the responsibility of enforcement from the state and put it in the hands of private citizens. Listen to this, Madam President. As a result of this Texas law, they have turned ordinary citizens into bounty hunters. I want to clarify something. I've read it and asked the Texas state representative to verify it. It's been said that you can sue a person who aids and abets an abortion in Texas and recover $10,000 costs and attorney's fees. That's not what the law said. The law says you can recover not less than $10,000 costs and attorney's fees. Some of the first lawsuits have been filed already against doctors involved in these clinics, and they're seeking damages in the amount of $100,000 and more. You don't even have to live in Texas to claim this bounty. Consider Dr. Alan Braid, the first person to be sued under this new Texas law. Earlier this month, Dr. Braid, a practicing OBGYN in San Antonio, penned an op-ed in the Washington Post explaining why he's continuing to provide abortions despite the law. As someone who has worked in medicine since 1972, the year before Roe versus Wade, Dr. Braid remembers the time when women could not safely access abortion care. He believes he has, quote, a duty of care to his patients, and he refuses to sit back and watch us return to 1972, in the doctor's own words. Well, as I mentioned, he's already facing the legal consequences of this new Texas law. Who exactly is the bounty hunter that filed the first lawsuit against him? Oh, you might guess a fellow Texan, right? You're wrong. It's a disbarred lawyer who lives in Arkansas, a bounty hunter. $100,000 is what he thinks this law is going to give him. That lawsuit being filed against Dr. Braid illustrates how irregular this Texas law's bounty hunter enforcement model is. Anyone from any state can file a lawsuit against any physician, but when we include the categories of people who aid and abet the person receiving the abortion, the categories go wide afield, from the people who gave her advice, the folks who gave the transportation to the clinic, a minister who counseled her. All of these things make them eligible to be sued for a minimum of $10,000 now in Texas. There's a reason why the Texas legislators designed the law this way. They sensed an opportunity on the Supreme Court. They knew an emergency legal challenge to this Texas law had a good chance of coming all the way to the Supreme Court. And they knew the Supreme Court has shown a willingness to allow sweeping changes in the law to take place through orders made on the shadow docket, on a short timetable without detailed explanation. It was interesting to listen to the Republican senators go into orbit over the fact that we would raise questions about the shadow docket. It is a motions docket where the justices on the Supreme Court can decide an issue on a very short time frame without even explaining their position. That's exactly what happened with SB 8. When the law came before the Supreme Court, a majority of Supreme Court justices, late at night, allowed it to take effect. The next day, the court issued a one-paragraph opinion to explain it. And it said it would not stay Texas's abortion ban because of the law's, quote, complex and novel procedural questions. In other words, the Texas legislators got their way. By designing SB 8 with a new bounty hunter enforcement model, Texas lawmakers managed to evade judicial review. In her dissent, Justice Sotomayor explained how this scheme worked. She said, the court has rewarded the state's effort to delay federal review of a plainly unconstitutional statute, enacted in disregard of the court's precedents through procedural entanglements of the state's own creation. The court's ruling on SB 8 is distressing for a number of reasons. For one, it has galvanized lawmakers across the country to undermine constitutional rights in their states. Over the past month, lawmakers and candidates in Arkansas, Florida, South Dakota, and other states have pledged to follow suit and copycat the Texas law. They saw what happened when this bill came before the Supreme Court. The Supreme Court basically said it can go forward. Additionally, the conservative majority on the Supreme Court has now signaled that it's willing to use the shadow docket to allow even laws unconstitutional on their face to take effect, as long as it aligns with certain ideological norms. Another witness we heard from today was Professor Steve Vladeck, an expert in constitutional law, has written extensively about the court's shifting use of the shadow docket. The shadow docket, of course, refers to situations in which the court issues decisions outside of the traditional merit docket. Historically, shadow docket orders are used to help resolve routine procedural questions, frequently issued without public deliberation, full briefing, or even signed opinions. But as Professor Vladeck testified, there has been a notable uptick in Supreme Court issuing shadow docket orders that are, quote, having a far broader substantive impact, for better or worse, compared to the emergency rulings in the past. And many of these shadow docket orders appear to be driven by ideology. Let me tell you why I say that. Listen to these numbers. During the 4-year presidency of Donald Trump, the Supreme Court issued 28 grants of emergency relief on the shadow docket at the request of the Trump administration. 28 grants of shadow docket relief out of 36 requests. Each of these orders advanced President Trump's political agenda, including one that allowed the resumption of federal executions for the first time in nearly 2 decades. Now let's do a comparison. If there were 36 requests of the Supreme Court for shadow docket opinions, and 28 of them were granted in the 4 years of Donald Trump, how about previous presidents? During the 16 years of the George Bush and Obama presidencies, from 2001 to 2017, the Supreme Court issued four orders in 16 years. In this last 4-year period of time, granted 28 out of 36 with the Trump Justice Department. With its handling of Texas abortion ban as well as other shadow docket orders, the Supreme Court's conservative majority has indicated a willingness to change substantive law in sweeping ways without due deliberation and public reporting. In doing so, they are undermining confidence in the court, and the conservative majority has opened the door for ideologically driven legal schemes to rewrite laws in the shadows like SB 8. This is a 5-alarm fire for due process, as well as our constitutional rights. And as I expressed during today's hearing, I hope every member of the Senate, Democrat or Republican, will join together to protect and preserve independent, transparent, and reasoned judicial decision-making based on the rule of law. At a time when the public's confidence in our governmental institutions has been greatly eroded, we must restore it. Madam President, I yield the floor.